So to start with, please tell us something about the new Housing Bill 2012. Its salient features and purpose and aim generally.
The new bill which will be converted into an act is called Maharashtra Housing Regulation and Development Act 2012. It shall be when introduced, it shall supersede the existing Maharashtra Ownership Flats Regulation of the Promotion of Construction, Sale, Management and Transfer Act 1963. The existing act and the new act are more or less for the control or regulation of the same aspect, but the existing act is not exhaustive enough, and the existing act did not provide a machinery to address the defaults or breaches of the existing act, and therefore this exhaustive act has been brought in. And the main, apart from so many other improvements, it will be in line with the present laws. That is, today, in order to overcome the delays in the legal system, there have been a trait wherein each law has its own tribunal and an appellate authority, so that the persons aggrieved under the said of the parties aggrieved by the said act do not have to run to civil courts where the disposal is not very far. The best example being the DRT, wherein the banking disputes were transferred all to the DRT and taken away from the Honorable High Court. Similarly, now tax tribunal is in the offing. Similarly, company law tribunal is also in the offing. So, in that same trend, this act also provides for an authority which will redress the disputes as well as an appellate authority. So, this is actually, we can be called as the biggest or the most cardinal deviation from the existing law. Besides that, this act also, the object of the act itself as provided in the preamble is to provide effective implementing arm for its various statutory provisions, as I already told you, as the flat purchaser could only approach consumer forum or civil court for acts or omission. Even the bill provides in its object as this as the main object of this act. Further, this act requires strict compliances and more transparency in the acts, deeds and things that the builders do. Therefore, by this bill, when it is made into an act, the builders will be exposed to much more closer scrutiny, and therefore, anything that is done which will breach, if even before a complaint can be made, it will be already known to the authorities, because I will come to that, because they are required to register themselves with the authority and there are certain requirements. Of course, these two are the main acts, and therefore it is mainly for effective regulation and of the provisions of the act.
Thank you very much, sir. Now next we will come to the question that to whom all does this housing bill applies to?
Now, see, in the earlier act as well as this act, there is a definition of promoter, and promoters are those who construct blocks of flats, blocks of buildings, etc. And this act is mainly applies to the promoters.
Right. How is this act ineffective in providing an implementing body for its various statutory provisions and reliefs?
You mean this act means the existing act?
Right.
Because the present act, as I already told, the present act includes all the machinery for making this bill effective. As already I stated earlier, existing act only provided certain obligations, rights and obligations on the part of the promoters, but it never provided any penal action against the promoter, and that was required to be done by going to a civil court. Now, that going to a civil court or a consumer court, you are aware that it doesn't get redressed very fast. Now, in order to solve that problem, and in that way, if you can say, it was ineffective, because certain aspects of breach of the earlier existing law could not have been gone to the consumer court, and in that case the only option was to go to the high court. or another civil code. Now other civil codes, that is High Court and the city civil, they take their own time. Therefore, it is also a matter of more cost, expenses and time consuming, which will be avoided by the introduction of the new act.
Alright. So next is what are the aims and objectives of the Maharashtra Housing Bill
See,
2012?
that itself, as I told you, salient features and the aims and objectives is the same. That also stands covered.
Under this new housing bill, who is the promoter and what are his duties and responsibilities?
See, the promoter was also defined under the old act. The same definition more or less is here, but it has been further expanded under the new act in order to include also, if a promoter himself is not a seller of the flat, if it is a selling agency, then even those persons who are marketing the flat would also be covered under the definition of promoter. Further, it says that even if a society itself is developing or a company is developing the property, or they are executing what promoter is otherwise supposed to be executing, they will also be deemed to be promoters under the definition. And therefore, if anybody who builds and a person who disposes, they are both included in the definition. The additional part of the definition is who constructs or causes to be constructed a block or building of flats for the purpose of disposing of by sale or otherwise, some or all of them or other persons, or to a company, cooperative society or other association of persons, and includes his assignees, and where the person who builds and the person who disposes of are different persons, the term includes both. Now this is addition to the definition of promoter.
So does the promoter gets any extra rights?
In fact, the act is for the benefit of the flat purchasers.
Right.
So I don't think the promoter should get any rights. Promoter is a businessman, he always markets this thing. But in spite of that, totally the earlier old act did not contain anything by which a promoter could do to a defaulting purchasers or a defaulting society. But this new bill does provide certain rights to the promoter, and that is under section 46 and 47. The rights of the promoter are,
The scope is wider now.
yes, but the rights are only for the recovering the money and penalty. Here it provides that even if a flat purchaser or allottee does not pay to the promoter, there is a penalty prescribed to the allottee of the flat or unit purchaser or organization. So this is one right which has been given. And secondly, if a person against whom any order is passed, other than the promoter also, and if he doesn't comply that order by housing regulatory authority, in that case also the act provides that he can be penalized. So it is not only the promoter who can be penalized, it is also the flat purchaser or this thing will be penalized. So except that there is no further any benefit, and obviously there cannot be.
So next question is there a need for registration of agreement for sale and displaying it on the regulatory authority's website? And what are the formalities and procedure for the registration as per this housing bill?
See, the need for registration is not under this act. The need for registration is under the Stamp Act, you pay stamp duty. Under the Registration Act, you have to pay registration. But in earlier act did not contain, and that was one big handicap, that even if the builder didn't register and if the agreement was not registered, the affected person could not go to court of law. This particular thing has been covered by the new act. This act specially provides effect of non-registration of agreement. Earlier act, it was that if it was not registered, it was not able to be introduced. Now this is travelling away from it, and in fact it supersedes so many things which are common law things, particularly the Transfer of Property Act, Specific Relief Act and Evidence Act. Now this act provides that even if the agreement is not registered, it can be admissible in the evidence. Then it can, even an unregistered, with an unregistered agreement, you can proceed against the builder for specific relief. Besides this agreement, though not registered, it can be considered as an agreement under section 53 for the agreement for the purpose of 53A of the Transfer of Property Act. Now, therefore, any handicap under an agreement which is compulsory required to be registered, if not registered, is not here in case of agreements between a promoter and a flat purchaser. So, this is a very I can say that a long important provision.
The next is what does the bill provide with respect to alterations or additions made by the promoter without consent of the flat owner or the property owner?
Now, this bill provides that after the agreements are executed, he will not make any change in the plans. Means the plans which have been first established, passed, he will not be able to make any changes in the plan without the consent of the permission of the flat purchase.
Right. And can a promoter create a mortgage without the consent of the parties after the execution of sale agreement?
No, even that is prohibited. Even earlier in the old act, and I think it is also here, that if an encumbrance or a mortgage is created, first and foremost is the promoter has to disclose such encumbrance in the agreement. Now, sometimes if it is after the agreement is executed, there is no scope for disclosure, and therefore in this act they have rightly covered that, stating that after the execution of agreement with with the parties, there will be no mortgage etc. without the consent of the parties. But property cannot be encumbered after execution of agreement, because there is no method of communicating to him. So here it requires a consent from the flat purchasers.
So it fairly deals with both the parties. The next question is, kindly shed some light on the housing regulatory authority established under this bill, like its constitution and qualification of members.
Now, provisions of section 23 onwards, they provide all the powers, appointment etc. of housing regulatory body. Now, this housing regulatory body has two arms of function. One is it has enough administrative functions also. At the same time, it has functions to redress the grievances. Now, this redressal of grievances is upon a complaint. Further, the regulatory under this act, the regulatory body has even right to suo motu proceed against the promoter for any defaults made by him. In the responsibilities of the promoter, section 4 requires the promoter to register the whole project with the website of the housing regulatory authority. Now, this registering of housing website with the housing regulatory authority also gives what all things he must upload on the this site, and this site being whatever this thing will be publicized in the agreement also, and otherwise people can access this site and know everything about the project, and all the agreements executed by the promoter would be uploaded on the site, and this will give a transparency to the transaction between the promoter and the outside. And housing regulatory authority under this act, one of the function is to regulate this, to find, and housing regulatory authority has also power to cancel the registration of a promoter who does not comply with this requirement. So, this is one of the new features of this bill, wherein the housing regulatory authority has its own site of each. On the site of the housing, each project of each promoter will be uploaded, and such this thing that can be accessed by everybody. So, there will be complete transparency about the documents etc. And if a document is entered into and not uploaded, it permits the housing regulatory authority to cancel it.
So it protects the right to information also. So the next question is, please explain the establishment of Housing Appellate Tribunal as provided by the bill, and its constitution and qualification of members.
I think a constitution of first of all housing regulatory authority will go through, right, and then the appointment. Of course, one more thing is not missing is there is also a appointment of competent authority under this act. Now this competent authority under the Act has very limited functions, and it is like it will be apported like a per ward basis or for distinct areas. Now this competent authority also has certain functions by which it can regulate, or it can promoters have to report to them certain things of the housing or the competent authority. But competent authority does not have as much as wide powers as the regulatory authority, which has very wide powers. Now coming to the power establishment of housing regulatory, it provides that it will have a chairperson. Now the chairperson which is required to be has to be a chairperson of this prohibits appointment of any government servant as a chairperson below the rank of principal secretary of the state government or an equivalent post of the central government. Therefore, other bureaucrats lower than that cannot be appointed as chairpersons of the regulatory body. Now, chairpersons have dual functions, that he is an administrative head also, as well as in the case of disposal of complaints and passing of orders, he will be the chairperson in the district. Besides the chair, the constitution is of 3 persons, and it will be, besides chairperson there will be 2 more members, and the requirement of appointment for members also and the chairpersons are the same.
Alright, sir. Then next is the powers and functions of that appellate tribunal.
Now, again going back to your earlier question, the members, chairperson, as I told you, should not be a government officer and not below the rank, but the members who are of the regulatory body, the government has given powers to appoint them from a wide range of persons, namely any person who has special knowledge of and professional experience in the field of public administration, urban development, housing, finance, law and management. Therefore, this will permit the regulatory body to appoint people from specialized branches in order to give effective redress to the complaints under this. And the chairperson who is there, that as I told, it should be, he should be nothing, government shall not appoint a chairperson unless such person holding or has held principal secretary or equivalent in the central government.
Right, sir. And whether the order which is passed by the appellate tribunal will be treated as a decree? Like,
no, it is provided that it is specifically provided that the order passed by the appellate tribunal will act as a decree. It is specifically provided.
Now, so does this bill provide any right to appeal from the decision of housing appellate tribunal?
It provides that appeal will be directly to the High Court, from the appellate tribunal.
Alright, sir. And does this bill apply to the redevelopment projects?
See, if you go to the definition of promoter, now even in the redevelopment project, this will apply. Therefore, there is no question whether society itself is redeveloping its own property, whether the landlord is himself redeveloping his own property, or society and a landlord if they appoint a promoter. In case of where it is redeveloped, in all these cases, the Act, though not specifically provided, by inference and by the definition, any redevelopment activity carried out by anybody, that's why the definition has been made wider in order to include everybody, society, company, property, other things. And whoever constructs a block of flats with intention of selling, he will be covered under the Act.
Right, sir. And the last one is regarding the transfer of property. You have already...
Transfer of property is specifically stated that it will not come in the way if the agreement is not registered, or it will be construed as a part performance under 53A. And but one more aspect of this bill which you should I want to say highlight is here that competent authority has a power akin to the power vested in the deemed conveyance, provisions of deemed conveyance under this thing. No, it is not made clear whether that that act also will be superseded or not. But here, if a conveyance is not executed by the developer, then in that case the competent authority has a power to treat to hear the parties and make an order which shall be deemed to be a deemed conveyance, which shall be a deemed conveyance which can be registered. Now section 19 subsection 5 provides that the competent authority shall have power to order unilateral execution of the conveyance deed, conveying the property to the society. So that power, now presently we have a act provision wherein deemed conveyance is a facility which is with the cooperative department, because generally under the act you have to convert the property into an ownership flat when you are buying, into a society, company or a condominium, and this act covers all the three. And similarly, if that also gives power to a deemed conveyance power to the deputy registrar or this thing under the Cooperative Act. But here, therefore, in this act, the competent authority under this act itself has that power.
Thank you very much, sir. Thank you once again for giving your valuable time for us. I'm sure now all our viewers are aware of this new bill and of this new topic. Thank you very much.
Welcome.